Hang
on
on.
coercive control, a considered conversation. This is our third and final webinar for the year. I'd like to start by acknowledging the traditional owners on the land on which we're all gathered across Australia today. I'm meeting with you on Condolences land in southeast Queensland out in the Redlands, but for yourselves, you will be meeting on other precious sacred land. So I ask you also, in your own way, to acknowledge the land on which we're gathered. Pay our respects to owners past, present and emerging. This is, I said, our third and final webinar, coercive control. It has been in the media a lot. Our intentions of having this was, I guess, well before anything emerged in the media, but now it's pertinent that it does. Here in Queensland, the Attorney-General, Minister Sharon Fentman, has announced that there will be consideration of coercive control within the criminal code. She hasn't specified whether that's a standalone specific criminal offence or incorporated into other aspects of criminal law. But in the coming months, you will all be asked to consider where you sit within your own organisations or as personal. You will also be asked to consider, I guess, developing position papers and submissions. Today, you're going to hear from a diverse range of people that you can see here on our panel. We thank them all for joining. This isn't a debate. You'll be hearing from people with diverse range of experience, expertise and opinions, all valuable. We're pleased to have such a great number of people that have come onto the panel and accepted our invitation to do so. To keep this moving along as quickly as possible, their bios are being put into a document into the chat room, and I'll please ask you to read them in its full entirety. We won't be reading the full bios out, but I think they stand as a testimony to the background and expertise of all our panellists. We've got 297 registered for the webinar today, so thank you one and all. We have people drawn right across the board from women's services, women's shelters, government policy, police, justice and courts, community corrections, health, etc. I guess before I start, a few comments I want to make. And the first is I probably want to acknowledge, I guess, the women out there that live every day with domestic violence. I've worked across this field for over 30 years. And in that time, I've spoken to hundreds of women. And no one can speak in a definite way on behalf of a whole group of women who are survivors, because their experience is quite different, I guess, to each other's. But what has disturbed me in recent times in the media is where now there's comparison about types of violence. Is emotional abuse, is coercive control more damaging than physical violence? And that's been said on several occasions. Can we please refrain from that? To the victims I know that have suffered stroke from strangulation, that now spend the rest of their life in wheelchairs, women with brain injury from being thrown against walls, women who are living with the trauma of being violently raped. We owe it all to them to honour their experiences as well. Every form of domestic violence is damaging, every single one. And so to all the survivors of domestic violence out there, we hear you and we believe you, whatever your experience is. I also want to give acknowledgement and honour to a wonderful woman that I knew in life before she passed away, and had met with her on several occasions, and that is Pence. People who've worked across this field would be very familiar with the power and control wheel. And that was developed in 1984 by Ellen, and it has been the formation of much of our training, the curriculum for men's programs for many years. Ellen developed that after talking to hundreds of women, talking about the tactics that men use against their partners, and certainly, came to the conclusion that power and control sat at the base of all violence, that it is an element of what we are now talking about today. But in the context of high-risk behaviour, here in Queensland, going across 2 domestic violence death review reports, power and control was identified between 36% and 42%. By far, the highest risk indicator is still actual or pending separation. And that, while we're drawing down from the UK in the difference that coercive control's making, there has been a release of the femicide census report spanning 10 years. There has been no reduction in the homicide there as there has in Australia. And pending and actual separation is still their highest risk indicator. I think we've got to base our conversations going forward on fact, and we've got to base them on what we know is the reality of women's lives and what we can hope to achieve from it. That's enough for me moving forward, but as I said, there'll be a variety of discussions. If you have questions, please pop them into the chat. Tanya will be monitoring them as we go, and we look forward to that discussion at the end. But it gives great pleasure now to hand over to Thelma Schwartz. The rest of us will be disappearing for a while and coming back. Thelma is from the Queensland Indigenous Family Violence Legal Service in Cairns, and we're absolutely delighted to have Thelma join us. Thank you, Thelma.
Thank you, Betty, for that introduction. And thank you, everyone, for joining us to really start this conversation about coercive control and its criminalisation. And I know it's quite it's a topic that sparked some division in the media reporting quite recently. Before I actually get started with that, I'd actually like to acknowledge the traditional custodians and owners of the lands that I'm on here in Cairns, the Gimoy, Wallabara, Yidinji and Uranganji peoples, and to pay my respect to their elders past, present and emerging, and to extend that respect to other Aboriginal and Torres Strait Islander people present on this forum today. I'd also like to acknowledge the traditional custodians and owners of the various lands that all participants are sitting on and meeting on in this virtual space, as well as acknowledging my own Torres Strait Islander heritage, my elders and my ancestors. That's a very important connection for me. You've got my biography as part of this platform. But in terms of who I am and why this work is so important for me, I've been practicing as a lawyer for 21 years, and I've had the benefit of working as a private lawyer in commercial litigation for a number of those years, as well as for a very long period, about 9.5 years, as a criminal defence lawyer for the Aboriginal and Torres Strait Islander Legal Service, ATSLS, here in Cairns, representing men, women and children in that criminal justice system. I've had, representation of men with checkered histories of continued breaches, contraventions of domestic and family violence protection orders, as well as associated assaults. So I certainly can understand that perspective, and some of what I will speak today is from that perspective. I'm currently and have been the Principal Legal Officer of the Queensland Indigenous Family Violence Legal Service, QIFVLS. I've been here for close to 5 years. QIFVLS is an Aboriginal and Torres Strait Islander community-controlled organisation. We are a specialist organisation providing specialist domestic and family violence services, both legal and non, for victim survivors identifying as Aboriginal and Torres Strait Islander in Queensland. We have 5 offices across the state, including our head office, which is located in Cairns with a service delivery office, Townsville, Rockhampton, Mount Isa, and a discrete footprint in Brisbane. We service over 50 Aboriginal and Torres Strait Islander regional and remote communities. And we go as far north as Bamaga in the Northern Peninsula area, and all those areas in between, right down to our Brisbane catchment footprint. We obviously do a lot of work with domestic and family violence in support provisions in terms of court work and non-legal supports, child protection, family law, victims assist applications, and I'm probably forgetting something here, and some minor civil work as well, QCAT. So I can speak also for victim experiences, given the nature of the work that I have done and continue to do for QIFVLS, and particularly the relevance that it has in terms of speaking for Aboriginal and Torres Strait Islander peoples. Okay, QIFVLS as a specialist family violence prevention legal service unit, and there are 14 of us across Australia, obviously is right on the coalface of family violence matters. And obviously there is an intersection here, and I've heard this said in the media and broadly around, well, if we're going to criminalise coercive control, aren't you by default then going to contribute to the overrepresentation of Aboriginal and Torres Strait Islander men going into prison? I want to be really clear with this. We have to come back to a point of accountability. And the behaviours we're talking about here, coercive control, is a behaviour. It's a behaviour that imprisons a woman, and it is gendered when you look at the statistics, within a home, and the flow and effect that that behaviour then has upon her children. These learned behaviours that then contribute to an ongoing connection with, unfortunately, the child protection system, the criminal justice system, the domestic and family violence system, and the family law system. So we see these patterns of intersections and connections with the justice system, and overrepresentation across all spheres. Having said that, QIFVLS as an entity and a body support the discussion and the creation of a criminal law offence of coercive control, making that an offence, a standalone offence. We've seen that done with the standalone offence of strangulation. And I think what we're doing here, and it's been my experience, unfortunately, you know, as a defence lawyer, we would see, you know, this disparity between, well, there's no physical violence, so that diminishes the type of sentence that I'm going to impose. Now, I've been through a number of those appearances in the Magistrates Court, and as a defence solicitor, I've made those submissions to distinguish the level of violence. But I agree with Betty that violence is violence. It doesn't take away what a victim of domestic and family violence is going through. And when you look through what has been reported about Hannah Clark and what she went through leading up to her death and the death of her children, you could see an ongoing pattern of control. I think we need to, with respect, and I that I'm advocating for the criminalisation of coercive control, we also need to look at measures of behavioural change, working with children, and particularly accountability with men. This is about making men accountable for their behaviour. It is also about looking at gender roles. So I think, I know I've heard the bell, so I'm getting the wind-up call here. All of these things are linked. There needs to be a change in trajectory, and, you know, I certainly am strongly advocating for keeping our women and our children safe, but just note that it is one of the raft of measures used to keep our women and children safe. And we need to start focusing on earlier intervention models, working with men, working with families, and actually an education campaign about behaviours that we are saying these are not acceptable. You know, this is not going to be accepted by our communities, whether you're an Aboriginal or Torres Strait Islander person or not. We have to draw a line and be firm with it. I think I might just stop there. I know that bell's thrown me.
Thank you, Thelma. And we'll certainly come back to Thelma when we hear from other panellists, but thank you very much for that. I did mean earlier to, there's a question popped up about, sorry, I'll just find it, about definitions. I don't know about other states, but Queensland does have coercive control within our Domestic and Family Violence Protection Act. And it describes coerce a person who the means to compel or force a person to do or refrain from doing something. And then it goes on to describe unauthorised surveillance of a person, unreasonable monitoring, tracking of a person's movements or activities, interpersonal associations without that person's consent, including using technology. And then it gives some examples. It is in the Domestic Violence Protection Act, but others may, if you have examples of where someone has been able to get a protection order solely on coercive control, I'd like to hear from them, because that's probably not our experience. I'm going to hand over now to Di Macleod, who's the CEO of the Gold Coast Centre Against Sexual Violence. And please read Di's bio as well. Good morning, welcome, Di.
Thank you, Betty. Firstly, I'd like to pay my respects to the traditional owners of the land, the various lands on which we meet today. I am standing on Kumbermeri country. I'd like to acknowledge the elders, past, present and emerging, and also to recognise that these lands were never ceded and always were, always will be Aboriginal land. As Betty said, you can see my bio. I've worked in the area of violence against women and children for over 40 years, and comments that I'm making today are drawn from my experience supporting women in frontline services during this time. So at this point in time, I really don't think that legislation will significantly change things for the women that I work with. I'm not convinced that a new criminal offence would make any difference if the actual goal is to keep victim survivors safer and to hold victims accountable. Firstly, we need to be on the same page and agree on a comprehensive, inclusive definition as a community before we embark on any criminal legal definition. I see coercive control as purposeful, strategic oppression that is gendered in nature, most often perpetrated by men against women. And this oppression sets the context of domestic violence relationships in the same way as oppression sets the context for the patriarchy. It is the context in which a myriad of controlling behaviours are enacted in order to maintain power. These behaviours are not a series of one-off incidents, but rather a pattern of behaviour, which may include non-physical abuse, such as verbal, economic, social, emotional, and psychological abuse, as well as physical and sexual violence. It's important for us all to recognise that this is the everyday contextual reality for many victim survivors of DV. I agree we need to look further than overt physical and sexual violence and recognise that verbal, emotional, physical abuse has significant impacts as well. The behaviour is clearly wrong, but is criminalising it really the answer? When we review our current legislation and criminal justice response, Well, I think the reviewing of our current legislation and criminal justice response is imperative before introducing anything new. Rather than piling on more legislation, we need to ask, will this simply create another barrier for victim survivors to negotiate? Could there be unintended consequences, particularly for the most vulnerable? Could offenders manipulate the intent of the legislation? Could current laws be used more effectively to arrest, charge and convict offenders who are currently getting away with all forms of abuse? In Queensland, as Betty said, we have coercive control named in our Domestic Violence Protection Act, and we have a range of other behaviours that are embedded in our criminal code. Physical assault, torture, sexual assault, rape, stalking, strangulation, and others. Much of this criminal legislation, however, is underutilised in relation to intimate partners. We find charges are difficult to progress through the criminal justice system, and it's very difficult to get a conviction, even though sexual violence, strangulation, and stalking are clearly identified as predictors of intimate partner homicide. I'd be hesitant to introduce new legislation when we can't always get traction for very serious crimes already legislated. We currently have consent and mistake of fact, as well as strangulation legislation amendments being reviewed. I think we need resourcing and comprehensive training for police, prosecutors, court workers, and the judiciary to improve investigation and implementation of current and impending legislation first. And I guess, we're starting to look at the experience from other jurisdictions where legislation has been introduced. So far, there's not much empirical research on how this is working in practice, but what is available is hardly inspiring, varying from a low uptake of legislation in Tasmania to higher reporting rates that sadly don't have a correspondingly high rate of conviction in England, Wales and Scotland. So for me, that raises serious questions about the accountability of offenders and the safety of those victim survivors who reported in good faith. What is the victim survivor experience and understanding of coercive control? We need to be taking that into account. Most women living with a violent partner won't know what coercive control is. In my experience, those who live in the context of coercive control seldom identify this whilst they're still living with the offender. Understanding this behaviour and naming it is most likely to happen after separation and through counselling and/or their own research. The broad community understanding of domestic and family violence is still, despite many years of education, very much associated with physical abuse and visible injuries. Invisible abuse does not fit this narrative, so when victim survivors are unable to identify and name their partner's behaviour as wrong or dangerous, they don't disclose, they don't seek help or report to the police. Well, why would they? What would that conversation even sound like? And even though coercive control is contained within our legislation, I've found it very unlikely for women to seek help or specifically report a standalone emotional and psychological abuse to police unless there is an overt threat or a physical and or sexual tipping point. Then it is this tipping point that gives them permission to discuss and unpack the context of control in which they live. I think it's really unrealistic and naive to think that simply criminalising coercive control will organically help victim survivors identify the behaviour they are experiencing as not just wrong, but criminal. And then somehow that recognition would further encourage them to disclose to friends and family or report this criminal behaviour to police. It's also unrealistic to think this legislative change may cause offenders to suddenly rethink their controlling behaviour now that it has been criminalised. If we want our community to understand and to identify, disclose and discuss coercive control, we need to embark on a well-resourced public education and awareness campaign, as well as a prevention education focused on young people. If legislation is to be introduced, it must be preceded by significant education, training and resourcing in health, welfare, as well as the justice systems, from police to court staff and judicial members. I believe the transformative change we're seeking to address, it is not going to come via the criminalisation of coercive control. I think we need to step back. We need to clarify the definition and goals. What are we talking about? What are we trying to achieve? Then we need to review current Queensland legislation, explore legislation and outcomes in other jurisdictions, consult widely and educate broadly before committing to criminalising coercive control in Queensland. Thank you.
Thank you, Di. I think it's important that we also acknowledge the great work Di's done in trying to bring forward sexual violence as a key factor in domestic violence. And Di and I have been working in trying to get the recognition of the role sexual violence has with strangulation, that so many victims of strangulation are also victims of sexual abuse at the same time. So Di's right, there's still a lot to do. Thank you. Gives me great pleasure now to introduce Molly. Molly's an associate professor at Griffith University, and Molly has also a renowned author on the subject of men and violence. Welcome, Molly.
Hi, everyone. I hope that the background noise isn't too terrible. They've literally just fired up an industrial wood chipper outside of my office. One of the dangers of working remotely. So I'd like to respectfully acknowledge the traditional owners of the lands where I'm sitting. That's the Minjungbal people, and pay my respect to their elders, past, present, and emerging, and also pay my respects to all Aboriginal and Torres Strait Islander people in attendance here today on all of the different lands across Australia. I really appreciate the comments of everyone that's already spoken today. I agree with everything that's been said, even though the positions are in a little bit of contradiction with each other. So I was really pleased to hear about the webinar today to allow for some open conversation to facilitate this exchange of concerns and ideas. I guess, given the areas that have already been covered, I'd like to just highlight a couple issues that have not been raised yet. And in my role as a professor, naturally, I agree with everything Di said about advocating, training, and education. I would love to see more of that happening. But where we're situated right now in Australia, a couple of the concerns that I have that come from what I've heard from survivors and practitioners who work in the field. And I just like to acknowledge that there are practitioners and survivors from every different possible community that have conflicting opinions on this issue. So respectfully acknowledging that. One of the concerns that comes up for me as someone who's been researching domestic violence in the family court space is how typologies are currently being misused already in Australia in the family law situation and in family courts. So we had some typologies proposed to try and solve some of the debates about whether or not domestic violence was a gendered issue. And those typologies were proposed to deal with the conflicting research findings that come out of research using different research methods and accessing different populations of people. So the typologies proposed, for example, what Michael Johnson called intimate terrorism, and that has sort of morphed into now this popularization of the term coercive control. But Johnson also described self-defense as a different type of violence, and what he termed situational abuse or common couple violence. So my concern about introducing a greater focus on coercive control as a criminal charge is seeing what's already happening in the family court. So in the family court, it's the case that magistrates are using this typology idea to set aside coercive control and make a distinction between types of violence based on very little evidence often, to make a distinction between whether something is situational violence or coercive control. And unfortunately, what we're seeing in the family court is often the magistrates will actually use this idea of coercive control, and particularly picking up on the idea that it's a pattern of repeated behavior, to actually raise the bar for required corroborative information like official convictions and evidence, and using that to actually raise the bar rather than broaden the lens, as is the intent of the coercive control idea. So for example, in family court, in one case, that example that comes to mind, the magistrate in the family court had a case in front of him where there was a criminal conviction for multiple serious acts of physical violence, and there was an active domestic violence order in place at the time, but the magistrate said, well, we know there was this one incident that happened leading to this conviction in this case. However, clearly this is situational violence rather than coercive control, because we've just got the one conviction. Therefore, there's no need to protect the children, and we should go with the shared care arrangement with shared parental responsibility. So seeing that sort of legal reasoning and logic really scares me a bit when I think about this coercive control language in the criminal code. And so one of the concerns that I have is that a greater focus on coercive control may actually backfire and lead to the demand for more corroborative evidence, which is already seems a bit disproportionate in domestic and family violence cases. The other concern that I have is sort of in the opposite direction. And that's because although coercive control, as described by Evan Stark, who's the most cited source, but coercive control has been described by feminist researchers going back to the 1970s. The earliest feminist researchers, Lenore Walker, even uses that language about coercive control. That theory is based on a body of empirical research about men's violence against women in heterosexual couples. And it's empirically based on that evidence set. We don't yet have the research to understand or know how that concept of coercive control, or if it applies to other types of couples, for example, same-sex couples. We don't know if the idea of coercive control applies to cases where there's a male offender and well, we know that there's evidence when there's a male offender and a female victim, but we don't know if the reverse is true because it is empirically based on research from one population, and we can't assume that that research and the same risk factors and patterns and dynamics of abuse apply in different situations. It would appear from the research evidence that we have, for example, from the Queensland Domestic and Family Violence Death Review Board, all of the statistics we have from the Australian Institute of Criminology, research that we have from AIFS, the Australian Institute of Family Studies, all the stuff coming out from ANROS, that the risk factors in different types of couples and in different directions is quite different. So I would have concerns about applying a theory and a pattern of behavior, and specifically an idea about risk, to populations that are not supported by the research. And I'll stop because I heard the bell.
Thank you, Molly. That's very informative. And I meant to say a bit earlier that Molly, Angela, Brian and myself that you're hearing from today are all members of the Queensland Domestic and Family Violence Death Review Board. And we have been reviewing deaths in clusters, and certainly, you know, the background and circumstances are quite different. But as Molly rightly says, there is no research to back up what those differences empirically are. Thank you, Molly. I'd like to now introduce Amani Hayder. I'm going to let Amani introduce herself because she has a very special story to share with all of us, and we're privileged to have Amani join us. Welcome, Amani.
Thank you, Betty. And before I start, I'd like to acknowledge and pay my respects to the traditional owners of the land on which we're all gathering, and also acknowledge that I'm zooming in from Darug country and that this land has never been ceded. And I pay my respects to elders past, present and future, recognising that when we have these discussions about violence and trauma, we need to bear in mind and remember the violence and trauma that has been inflicted in this land. I also want to convey my condolences to the victims of male violence who have lost their lives just this week. About a week ago, I was on Q&A and the number that I quoted then was 45 women. And now I think we're at 48, going by the record that's being kept by Counting Dead Women Australia. I lost my mum to domestic violence in 2015. She was murdered in her own home by my dad after many years of dealing with and facing emotional and psychological abuse and behaviours and patterns of behaviour that we would refer to now as coercive control. And I want to acknowledge that both Thelma and Di and also Molly have spoken to issues that I also agree with, even in the ways that they have challenged or disagreed with one another. I think that's part of the importance of this conversation, is acknowledging the complexity of the questions that we're dealing with and recognizing that we don't actually have all the answers immediately, and that there are gaps in the research and in terms of what we know and whether we can even measure the success of legislation overseas or what impact it will have locally. I found it really difficult when my mum was first murdered to put my finger on what the nature of the abuse had been, because I was socialized and used to the idea, as Di touched on, that violence is generally physical. I found it difficult to relate to kind of put the homicide into a narrative that made sense, because the situation I was in had really normalized a lot of the behaviors that I witnessed growing up and made me believe that my parents had a normal relationship. And it wasn't until I started understanding and researching and reading more into my mum's experiences that I could actually put my finger on it and say, oh, wow, this is not these homicides don't occur in a vacuum. It's not such a shock. It's really part of this broader power and control. And when I remember seeing The Will for the first time and really having it resonate with me and reminding me of my mum's experiences, which were of a more what I described as a more subtle form of abuse and harder for an outsider to the relationship to really point to. And I think it's great that we've been increasing awareness around the fact that that abuse is serious and that domestic violence homicide can take place without prior instances of severe physical violence or prior reports to the police. And some of the reasons that I think that's important is because for victim survivors such as myself, being able to understand and recognize that can be empowering as you go through the legal process. At the same time, I think the legal system falls short in its ability to capture those experiences. So to illustrate that, I know that giving evidence at my mum's trial was a particularly difficult experience for me because I was still trying to think back to instances of physical abuse. And whilst I included examples of coercive control in my evidence and my statement and was able to, by that point, recognize and identify them, the court didn't really make use of that information at all. The other issue was that my father was able to illustrate himself or portray himself in his through character references as, you know, I've never had a prior conviction. There's been no reports made against me previously. I'm of prior good character. And to challenge that when the people around you and the society around you believe that abuse looks a particular way and they don't really have an understanding of coercive control at all, is very difficult. So for me, there would be benefits in criminalizing what we're referring to as coercive control here. I have the same hesitations and reservations that have been expressed in relation to the ways in which the bill in New South Wales, the one that I've looked at, has been worded. I think it does kind of cast quite a broad and general scope. I think as well that we do need to be investing in and focusing on empowering young people to be able to identify this sort of behaviour in relationships through schools and through programs that will help them recognise when coercive control is taking place in a relationship. I've been in a classroom where the majority of it was teenage girls were unable to recognise that behaviours such as your partner regularly checking your phone, constantly needing to know your whereabouts, controlling your use of technology, your friendships and things like that. They didn't recognise any of those things as abuse and actually believed that that was a normal part of being in a relationship. And even a loving relationship. So I think that a lot of work needs to be done there. I think as well that the law does play a role in creating cultural shifts, and you can sometimes have that by criminalising something. You can create a sense of accountability and you can create a way forward for the people who are able to utilise and navigate the system and follow through with it and who want to do that. But as has been mentioned as well, I think there are a lot of victims who don't want to go down that path. So I know I sit on the board at Bankstown Women's Health Centre. A lot of my work focuses on, and my advocacy focuses on the needs of women from culturally and linguistically diverse backgrounds. And that can include navigating tensions between community and police, navigating skepticism about the system, women not wanting their partner incarcerated because they value or want a relationship with him still, or want the children to have a relationship with him still, or they don't feel financially secure to establish an independent life for themselves. And I think a lot of these issues frequently and regularly get overlooked because it is easier to make legislative change than it is to fund in the long term the types of programs and education that's needed to overcome these issues. So I think that having a law that responds to the needs of women in crisis who are experiencing coercive control and need to access justice and accountability through that route is important. I think we also need to have more than one entry point when it comes to justice and accountability. So I think we need to have an intersectional understanding of the types of oppression that people encounter in their everyday lives and the way that those things all play in with one another. I've also had experience working with youth in my local area, and again witnessed young men or teenage boys having a very basic or non-existent understanding about their own criminal liability and the types of things that they could be held accountable for. And again, that says to me that we do need to look at the preventative measures that we can be taking as a society, and early intervention and community-led responses, so that we can educate people rather than criminalise them down the track.
Thank you, Amani. What a privilege to have you, and to be able to draw on that experience that you've had from such a tragic loss, that we can all learn from that. So thank you.
Thank you.
I just wanted to go back to talking about the work we do on the Queensland Domestic Violence Death Review Board, and what a privilege that is to do that work. In all of the homicides we've looked at, there has not been any definitive risk factor. There are some that are higher than others, but every death has a combination of multiple risk factors prior to that homicide. But the other thing I want to draw attention to is that we cannot not overlook is systems failures, and that's been mentioned by several people this morning about what is the system around when we do law. And I'm not talking about one agency. In the 2018 report that we did, the average intersection with victims and perpetrators prior to that homicide was 28 agencies, multiple contacts with agencies, both government and non-government, and not necessarily saying people did the wrong thing. Often it's lack of collaboration, lack of integration, communication across agencies. But some agencies, victims went to multiple times. So in bringing in new law, my point is we've got to make sure not just that law's safe, but the victims are entering into very safe systems around them at that time. It gives me pleasure now to introduce Angela Lynch, the CEO of Women's Legal Service. Angela sits on the Domestic Violence Death Review Board as well. And Angela has considerable experiences, obviously, across various aspects of law. Good morning, Angela. Welcome. Angela, you're on mute still.
Thank you, Betty. Thank you for saying that. Sorry about that. Someone has to do it, don't they, in one of these webinars now. Thank you, Red Rose Foundation, for the opportunity to speak today. I would also like to pay my respects to the traditional owners of the land on which I am presenting, which is the Yagara and Turrbal people, and acknowledge elders past, present and new emerging, and to all those First Nations people that may be on this webinar today. The criminal law provides a baseline in our community of acceptable behaviour, and without a course of conduct coercive control offence, it sends a message to our community that coercive controlling behaviour is acceptable, or not as important, at least in relation to other harms. The criminal law, whether you like it or not, has a role to play in general deterrence and attitude change. It is not the entire response, and it never should be, but it is a key part, has a key part to play in perpetrator accountability. In fact, it is a fundamental way that our society holds perpetrators accountable, or those that transgress our laws. Coercive control is extremely harmful to women's psychological, short and long-term health. It is also a recognised precursor to very serious and potentially lethal domestic violence events. And what we know from the Domestic Violence Death Review Board, actually here in Queensland, is that the system generally didn't respond to those highly controlling events unless there was also physical violence attached to them, or the service system did not. Any criminalisation of coercive control will likely increase community understanding. Obviously, just even having all of these, this talk in the media, these discussions are really important for our clients and for the community generally to increase their understanding of coercive control. it can increase women's I think that if there is a criminalisation, it would increase women's understanding and men's understanding of what constitutes domestic violence and what is acceptable and unacceptable behaviour. It may actually mean that women recognise the dangers of controlling behaviour at an earlier time and act on that knowledge in the interests of safety. It gives them language of behaviour that they've lived with and haven't been able to verbalise. And obviously, if the service system itself as well is better able to listen to those or has greater knowledge around those issues, it's better able to respond. No matter whether a woman wants to take criminal action or not, it is a powerful statement to say to her, your experience is not only morally wrong and unacceptable, it is against the law. Imagine in a men's group and working with perpetrators, the group facilitators can also say this to men. Now we can only say that some aspects of DV are criminal. Yes, financial abuse, emotional and psychological abuse are condemned in our civil acts, Domestic Violence Protection Acts and the Family Law Act, in best practice manuals and the like. However, this is never as powerful as saying it is against the Criminal Code of Queensland. For 26 years, as part of Women's Legal Service Queensland, I've heard advocates lament the lack of understanding in the judiciary and legal system of the dynamics of domestic violence and the yawning gap between court decisions and women's lived experience of violence. This is despite the media attention, the training, the campaigns, and the law reform in this area. This gap continues to exist. The introduction of this offence, however, can provide the mechanism to change the system, and I'm particularly interested in changing legal culture. A key light bulb moment for me in supporting the establishment of a standalone offence was reading the case of the Crown and Hollis, a decision of the full court of the Court of Appeal of Queensland delivered on the 4th of February this year. The Court of Appeal was constituted by the President of the Court of Appeal in Queensland and 2 other eminent judicial officers, all of them men. The case is not particularly remarkable or groundbreaking legally, but it exemplified the issues of concern as just stated. Mr. Hollis was 71 years of age at the time of the commission of the offence, which was throwing several chairs at his female partner at a family event in front of witnesses, caught on CCTV footage, which caused her injury. She barricaded herself in the bathroom and the police were called. The police took out a temporary protection order on her behalf, and later she made a statement and he was charged. Not unsurprisingly, in those circumstances of overwhelming evidence against him, he pleaded guilty, and the female district court judge fined him and recorded a conviction saying his behaviour was utterly disgraceful, given the seriousness of the offence, the impact on the victim, the need to send a message to the community about deterrence in relation to domestic violence. He was also subsequently convicted on 2 occasions of breaching a domestic violence order for approaching her at a shopping centre and driving by and attending her house. The victim said she was terrified, humiliated and embarrassed. The defendant appealed the recording of the decision as manifestly excessive because the district court judge actually recorded the conviction as it impacted on his ability to retain his membership of a yachting club. It was noted in the judgment that his new evidence, which was contained in the Court of Appeal approach, contained disparaging and irrelevant assertions as to the conduct of the complainant, including as to her sexual activity. That evidence was dismissed, but it was interesting, it was not referred to or considered that it was part of a legal systems approach or a legal systems abuse of the complainant. The subsequent breaches were not considered as they were in a different category, noting specifically they did not involve allegations of violence, meaning physical violence. So the incident of physical violence was distinguished from the other psychological abuse breaches, and the Court of Appeal noted the impact of the social and economic well-being of the defendant, and they allowed the appeal, so the conviction was not recorded. The Court of Appeal is the highest court in Queensland. Their decisions are important as they cascade down and influence all decision-making in the courts below. And with the greatest respect, they were unable to see the pattern of violence that was so clear to us in the field. Their decision-making and court decision-making in turn influences police decision-making, who are also having an eye to how these court decisions are made in relation to where they put their resources and whether they charge somebody or not. The Court of Appeal decision and approach is an example of why we need such a monumental shift in our thinking. The current incident-based approach provides many opportunities to backfire on victims where a history of violence and the coercive and controlling aspects of the relationship are not considered in the charge. Of course, any new law may have unintended consequences, and that is why we must, it is very important to carefully develop the law with broad consultation and build in safeguards, not only to the legislation, but also to its being operative in the field. Criminalisation of the offence will mean lawyers are more aware of coercive control and its impact. It will promote lawyers asking a full history of all aspects of violence from their clients, and specifically to ask questions about the existence or not of controlling and coercive behaviour. Of course, if the law is in place, there will also be obligations on lawyers to refer their clients to the police to make a complaint if that is what the client wishes. It may also provide opportunities for better argued defences in criminal law for women who've been charged with a criminal offence in circumstances of domestic violence, including those women who've been charged with killing in circumstances of life-threatening domestic violence. It may provide opportunity for some accountability for sexual violence crimes, which our current system does not respond to well from a victim's perspective. The development of an offence will have an educative value across the spectrum of the legal profession, including family law, child protection, estates law, and any other law that victims come across. That's because they will be taught about it as a part of the criminal law approach when they're students, as they go on to lawyers, as those people move through the system, as they become magistrates and ultimately judges. I think it's important that any law, and I acknowledge the need for safeguards. I acknowledge the need for extensive statewide training. We have to invest in social change campaign. We have to update investigatory tools to better pick up on coercive control, update judicial bench books and guidelines, construct the offence around a reasonableness test, situate the offence under some guiding principles that talk about it being a gender-based crime, and that it may, and it has the same impact as physical assault or can, operationalise it in a way where maybe every police officer in Queensland hasn't got the ability to charge. Maybe there has to be sign off by a specially trained officer. We have to consider how many incidents are required to prove or establish a coercive controlling offence. Is it 2? Is it 3? Is it 5? Other systems have changed via law reform. Particularly, we can note strangulation and stalking. This isn't the first time that we have had legal reform-led culture change. I'll finish there.
Thank you, Angela. Lots of points to consider there, and I think Angela's right. It's a monumental shift about how we bring about some systemic change. And, you know, I think everyone's agreeing we need to prioritise the safety of victims as we move forward with this and look at how we implement the training and information and get that out into the community. Our next speaker is Dr. Brian Sullivan from Central Queensland University. Brian is also a board member of the Red Rose Foundation. Brian has a very extensive background in working with perpetrators of domestic violence, and that's the perspective he brings this morning. Thank you, Brian.
Thanks, Betty, and thanks everyone for attending, and thank you to the Red Rose Foundation for sponsoring this webinar. Like Angela, I'm on Turrbal and Jagera land, and I pay my respects to elders past, present and emerging. I'm going to share a screen, and hopefully this works for everyone. And I'm going to speak briefly to it. And I'm the only person with a PowerPoint, and I'm not doing it to show off. I just speak better when I have a PowerPoint to speak to. So I'm not trying to score points here, I promise. So coercive control, as we know, is not an isolated act. It's an atmosphere, it's an environment, it's a landscape in which a victim is living. I love this quote because I think it really sums up for me what the purpose and intention of coercive control is. There's nothing so dangerous as an enemy who builds an outpost in your own head. And that is what coercive control does when a perpetrator actually colonizes his victim's headspace, her mind, her identity, etc. And we know from working with perpetrators that they never start out as full-blown coercive controllers that are obvious to victims. They go from love bombing to brainwashing. They go from having her on a pedestal to putting her in the prison of that relationship, from infatuation to incarceration, and from devotion to her to deprivation and total dependency on him. I've developed an illustration which makes sense to me anyway, and it's about the complexity and the sophistication and the nuances of coercive control. It starts out from a belief in a man's superiority to women, that he actually owns his partner, and it's a sexual ownership, not just a personal ownership. And because of his ownership, he's entitled to her 100%. And if he doesn't get that, then it turns adversarial very, very quickly. So without touching her, he can use all these strategies of coercive control to cage her in, to imprison her. Intimidation, threats, gaslighting, isolation, verbal abuse, double standards, micro-regulation, including surveillance of her, playing the victim and himself, and obviously degradation of her. Evan Stark, who has been mentioned prior to this, talks about coercive control as depriving a woman of her dignity, of her equality, of her autonomy, and her liberty. And the purpose of this is to make her dependent, as I've said, totally debilitated and living in dread. So I'm not a lawyer, and I must apologise to all the legal people and all the criminal justice people who are present today if I sound silly or naive when it comes to the law. But I think, you know, this issue boils down to a couple of major questions. Do we believe in the symbolic power of law to change people's lives? And I'm not sure how I would answer that question myself. So I'm going to be raising questions that I don't actually have answers to. Can the law in and of itself affect change, especially in relation to intimate partner violence? Again, for some maybe, but I can't answer that myself. Laws never happen in a vacuum, do they? There's always a context post-legislation. So for judges, for prosecutors, for police, there would need to be this extensive education and training in a very complex area, such as coercive control. There needs to be the operationalization of the new offence of coercive control. How the law is interpreted and investigated, well, we already know now that there's no consistency across the board for other laws in terms of domestic violence. How do we do coercive control risk assessments? And then evidencing the charge. There's problems with evidencing in a lot of areas of domestic violence. This evidencing in this case seems to me particularly problematic. And then prosecuting and sentencing. If prosecuting doesn't happen, and from looking at the UK and Scotland and Tasmania, it does seem to be a little bit light on, especially early on in the legislation. And the sentencing was never to the full extent of the possible sentencing that was available. So in terms of a challenge of coercive control for court and police, I think it's that shift, isn't it? From investigating and charging isolated and particular incidents and instances versus protracted cumulative patterns of nuanced and complex behaviours. Course of conduct crimes are difficult to police, we know, and they tend to have lower conviction rates. So what does all that mean for a victim? Well, I've got a quote here, and it's not my quote, it's a quote of a partner of a man I worked with. You can't trust the system to work for you. So I'm looking at things maybe through her eyes somewhat here. If we cannot trust the system now, how is adding further legislation, notoriously difficult to convict, going to help victims? Shouldn't our focus be on fixing the system that we have and improving use of legislation that we already have for strangulation, stalking, domestic and family violence, where coercive control and the instilling of fear via threats and intimidation are already included? Have we carefully and comprehensively considered that phrase again, unintended consequences of such legislation? By the same token, have we carefully and comprehensively considered the unintended consequences of not having such legislation? What does new legislation do to improve our present response for victims of domestic and family violence? How could a perpetrator use the legislation to further coercively control his partner, especially if it is gender neutral legislation as it is in the UK? And you know, on another note, I've seen men and witnessed men in group coach each other on how to use the legal system against their partners. If coercive control legislation was implemented, how do we ensure that courts, police are trained in understanding and implementing such a cunning and subtle way of entrapping a victim where evidence may be difficult to not only obtain, but actually prove in a court of law? What are the effects on a woman of taking coercive controlling charge to court to only have it dismissed for lack of evidence or him receiving a trivial sentence? A recurring theme within coercive control investigations was victim disclosures being considered as weak or with non-verifiable forms of evidence, ultimately amounting to one word against another. Have the evaluations, the challenges, the learnings from the UK, Scotland and Tasmania shown us unequivocally to sign up for this legislation? In other words, are fatality rates lower because of this legislation in those jurisdictions? And I will leave you with this quote. Decades of policy and legislative reform of the criminal justice response to other forms of violence against women leave us somewhat pessimistic that the introduction of this new offence within Scotland's adversarial context, which sustains forms of legal practice known to effectively undermine the spirit of any well-intentioned legislation, will fully achieve its bold ambitions. Legislative change cannot on its own lead to improvements. Whatever laws we have will be only as effective as those who enforce, prosecute and apply them. Improving these practices through education, training and embedding best practice and domestic abuse expertise is likely to be more effective than the creation of new offences alone. Thank you.
Thank you, Brian. A lot of food for thought there too. And while you're speaking, Brian, I was thinking back to Ellen Pence and, you know, she made the statement that in her work, you know, in pioneering work again with, you know, the batterers programs in the US, she said, men don't desire to control women. They don't want to control women. It's more that they're entitled to. It's what society gives them in that entitlement. And it is a gendered crime and we need to keep focus on that. Could I just ask the panel to please now put back your mics and videos, and we're going to move to question time. And in doing that, I'd like to give a big thank you to everyone on the panel. If we were live, we'd certainly have a round of applause to all of you, because I think everyone has brought such a wealth of their own experience and, you know, diverse perspectives to this. And I think that's what we need going forward. I think that we will get the best outcome for women when we can all work together and share our own rich experiences. Some of the questions, first off, is that one of them is, how do we ensure that this legislation won't be used by abusers against their partners? So who'd like to start with that one?
I can start. We can never, any new law or any law can always be misused. And I think that in Queensland, there's a certain percentage of in the domestic violence protection order space where orders are taken out against women. But I think that it's in how we construct the offence and how we operationalise it. And that was what I sort of put in at the end around some safeguards. Number one, it is the criminal law, so it is proof beyond reasonable doubt. It is to be able to take the matter forward. I think you have to invest in statewide training of police. Particularly, I think that you have to, I think that we need consideration in Queensland about whether every officer can actually take it out. I'm kind of I feel that that may not be the case, that every officer in Queensland can charge, that there must be a sign off by a specially trained senior officer, but that's obviously up for discussion. And that's another way of protecting against misuse. Thanks,
Angela. I just want to make one comment. At the time when we were putting, I chaired the Queensland Domestic Violence Council for 2 terms, and we oversaw the development of the legislation. Well, not the development, but certainly a lot of the changes to it. With the insert of coercive control at that time, we did want to put into the legislation some understanding and definition of predominant aggressor. And I think that in understanding predominant aggressor, we have to look at who's in the most need of protection. The law should be there to protect the person at most risk. I have, read where there is a concern about misidentifying the predominant aggressor. But if we use the term misidentifying, we're actually saying someone's actually even doing an assessment to misidentify. I don't think we're even at that stage. I don't think there's any assessment before we get to misidentifying people. I think there's no training. I think there's no legislative background of how we can actually make sure that the law protects those it's intended to protect. But over to other people, or we move on to another question.
I might just add a comment there, Betty. I think that's a really valid and topical point. And we see that quite often in our regional and remote Aboriginal and Torres Strait Islander communities as to the misidentified victim. And this is about police arriving at a scene, seeing a woman outside covered in blood. And this is actually based on an actual case scenario, and I'm de-identifying it, covered in blood, holding a knife. They will then see the male victim standing outside with blood on him and a wound. Now, the police response was to then immediately charge her with an offence, to slap on a PPN, apprehend and remove her while her children are still in that house, and then speak and treat the victim. When she's then come to see us for assistance, and we as legal professionals and advocates perform our roles and functions and ask her questions and investigate, it's become predominantly clear that she has been the victim of ongoing physical, psychological, coercive control abuse mechanisms for the duration of that relationship. That didn't take us that long to identify that and to see that she is the true victim, the victim who should have been rightfully supported from the outset. So I absolutely agree. I think there needs to be a real focus on training our police, our first responders. And I agree with Angela's position in relation to not all police on the front line having the ability to charge that particular criminal code offence if it becomes enacted. I think there needs to be a vetting so that the system doesn't lose any more from it. And I think what we need to realise with respect is that it's part of a process. It's the end result. And I think we've got to be really careful in thinking and saying that only the court can resolve this. The court and the judiciary and our system there is part of it. It's a piece of the puzzle. And you need to look at all of those other pieces that contribute and where we can come in and support and educate and train. And this will take, it's not a short-term measure, these are long-term measures, and it will require long-term investment, policy and planning from government. We're seeing societal change, which is what we want to affect and how we live and move forward as a society.
Thanks, Thelma. I've got another question about, look, how do we ensure, because coercive control currently now is in, training documents that people have, information out there. So the question is, how do we ensure consistency of a definition? How do we develop a definition and then that's in law, and how do we ensure then there's consistency across it? Anyone want to have a go at that one?
Well, we ensure consistency just by extensive training and continual training. I think we develop a definition that will sit in the criminal code that provides a baseline, and there can be different definitions, because what's in the criminal code isn't necessarily what advocates will use or will utilize. It can be influential, but it won't be exactly the same. Yeah, I mean, we do it as like any kind of thing. You have to have that training, and you have to have that follow-up training. You can't just have one-off training. It has to be constant and continuous, and yeah, that the reinforcement of that through the system.
Thanks, Angela. Molly, there's a question for you where someone is asking for the earlier research that you referred to prior to Evan Stark.
Oh, well, this idea of coercive control and the definition of domestic violence as not just about physical violence, I mean, that's been built in from the earliest publications from the 1960s and 70s, where it was practitioners doing research out of the battered women's movement. So, I mean, there's hundreds of those sources. You could go back to Dobash and Dobash in 1977. You can go back to, well, any of those early sources have that language about power and control. And so this idea that Evan Stark just invented coercive control in 2007, he's very clear that that's not the case. So I think that's important to point out. Evan Stark's intention in relabeling or rebranding domestic violence as coercive control was just to highlight those non-physical types of abuse, but also 50% of the concept of coercive control, the way Evan Stark understands it, is structural patriarchal gender inequality. It's not just inequality, it's not just gender. It is the fact that domestic violence is often organized around gendered expectations of labor and roles in the household that are enforced with the threat of violence and backed up with all these micromanagement tactics. And that patriarchal inequality is also feeding what Dr. Brian Sullivan mentioned about this ability of abusers to image manage quite easily when they interact with systems where their word is taken with more credibility than women receive in the system. So I think that gender inequality that's been right through since the 1970s is still important to talk about. And I understand we haven't done that all the time because it's a difficult conversation. It's maybe less warm and fuzzy than talking about being opposed to violence, which everyone is opposed to violence. But we have to deal with those really deep inequality issues, and that gets right to the separation and the family law context as well.
But you can put, you could put situate the offence, or you can argue for the offence to be situated in the criminal code under some guiding principles that acknowledge gender-based crimes. I mean, certainly that's what we would be arguing for, so that acknowledgement cannot necessarily be absolutely constructed into the definition of the offence itself, but you can put it under, you can have these sort of tools at law to kind of push the court in a certain way when it ultimately makes these decisions.
There's quite a few questions that have come in about family law. You know, how do we ensure that what we develop in states, and each state will obviously have something quite different, but someone's asking, you know, how do we then ensure some consistency across interfamily law? Anyone want to have a quick go at that one?
Look, I think that's a very valid question, and one of the things people need to be aware of is there has been a Legislative Affairs Standing Committee review into an inquiry into domestic and family violence and sexual violence in Australia. That's happened recently. Submissions were taken with very broad terms of reference, and you know, they are looking at it from a Commonwealth perspective, and it's come about as a result of what's happened with Hannah Clark. And obviously all of those issues, those intersections and connectors that were brought to the surface when we've seen what occurred with Hannah and her children, and rightfully so. The family law system is another system that is undergoing current review at the moment. I believe currently coming soon is the merger bill to merge it and the Federal Circuit Court. So there's quite a structural reform in theory coming before Parliament. And I think this is another area of review that needs to be incorporated into the legislation, given that we know that women are most vulnerable when they're separating. And when women are separating from the relationship, they're often leaving with their children. And that exposes children to harm. And you don't have to look any further than what's occurred very publicly, and rightfully so, in terms of Hannah Clark and her kids and how that's just unfolded. And it's really leading us to have these conversations, and they are quite uncomfortable, but we need to have these conversations about how do we make it better to ensure that no other woman and her children goes through this again, and they can actually have faith and belief in systems that are designed to protect them. They are citizens. They are people. We have a Human Rights Act in Queensland that in theory enshrines basic human rights. Yet there's a cohort with respect in terms of coercive control that we see as those invisible victims. And obviously we fight for and we advocate for to get them acknowledged, to get them fully protected, to actually participate and be part of a free society. So I know I'm going on my soapbox a bit, but it does for me touch on a lot of these fundamental core concepts of social justice. And it is quite gendered, and it is really about empowerment, and our courts actually accepting that, you know, seeing empowered women and empowerment of, you know, gender politics. I'm going to stop mute now.
Thank you, Thelma. And I just want to put out there too just a comment that, you know, we at the Red Rose Foundation are passionate about ending all violence, and we acknowledge the tragedy that occurred with Hannah and her children. But let's not forget, last year in Queensland, children were also killed. And in the context of domestic violence, there was 37 homicides during 2019 related to domestic violence. And out of that, there were 17 children killed. And there was the Ritter children that were murdered in Mount Isa, blown up by their father. So we've got to make sure that our systems and our interventions and everywhere aren't forgetting, you know, the shocking toll domestic violence Amani started by acknowledging yesterday, 2 women died in Australia yesterday. A child is critically in hospital, as is another woman. Our time's almost up, but I'm just going to pass it to everyone. If we can start at the top with Molly and go round for one closing comment. Thank you.
I really appreciate all the comments that everyone has made in favor of education. Obviously, as a professor, that's a big deal for me, but I work at a university in a department where we do not have a domestic violence class in my program, and I've been advocating for it from within and making no headway. So I really appreciate all the calls for education and training. I think a lot of the universities require a little external pressure to push this forward. But thank you so much for all of that. I really appreciate everyone's comments and hearing about all your insights today.
Right.
I think I agree with Molly. Certainly in our undergraduate psych and social work programs, we need a lot more education on domestic violence and specifically coercive control. I would like to see, I think, us hasten cautiously forward, looking at evidence and outcomes from places which have had this legislation in place first and foremost. And I think it would be good to hear from victims' voices who have been in the situation before we jump on bandwagons.
Thanks, Brian. Thelma?
Thank you. Thank you again, Betty, and the Red Rose Foundation for having me here today. Thank you to the panelists. Thank you for really insightful comments and viewpoints. And it's been a real pleasure. I think this is the type of conversation that we need to have, that we're mature and ready to have. And I think we need to look at bigger picture reforms. You know my point. I do believe that it is one tool in terms of criminalising this offence. I believe strongly in that. I believe, though, that we should look at it in an informed way. We should hear from victims. They should be front and centre of this, but not forgetting those children and the impacts on our kids, because they're the next generation. They are our hope. And I'll leave you with this: simply because it's too hard and it appears too hard doesn't mean we shouldn't do it. If things were too hard, we would never have put men on the moon or put planes in the air.
Thank you. Thank you, Thelma. Di?
Yeah, look, I think until coercive control is actually embedded in our collective consciousness as criminal, we're not going to get a massive uptake in reporting from survivors who simply won't identify it. And I use an example of intimate partner sexual violence, criminalised in Queensland 31 years ago, and we suddenly thought there'll be masses of women coming through who experience this on a regular basis, but very few reports of intimate partner sexual violence, very few getting through the criminal justice system, and even less convictions. So in relation to coercive control, the criminalising of coercive control, I would say stop, explore and educate before we legislate. That's it.
Thanks, Di. And
I'm not jumping on any bandwagon. Our position's been carefully thought out, and I know how lawyers think, and you are not going to get a shift in how lawyers think, who make up these powerful institutions where we go in relation to safety, I believe, unless we do have the criminal offence. And I see it as an early intervention tool, because I think that women, once it becomes a criminal offence, which sends a powerful message out into our community, women will identify it. Not every woman who's been a victim is going to go through a criminal process, but at least it sends a message that she can go to a service and it can give her the language to talk about it, and also gives the message to violent men as well. So I look forward to the community conversation that's going to take place here in Queensland, and obviously participating in that, learning from that, and looking at ways that we can make the system as safe as possible.
Thanks, Ange. Amani?
It's very difficult to sum up a position after hearing so many different compelling perspectives. But for me, I still think that criminalising coercive control can provide a language and a framework that would be useful for the people who need that support during crisis. I do agree that we need to be careful and not rush in terms of legislation, because I think getting it wrong has also got huge consequences for the people involved. And once that trauma has taken place, then it's very hard to undo the damage. I think it's really important that we continue to elevate and listen to the different voices of victim survivors, which are not always the same. We have different approaches to things, and some of us do believe in and have experienced accountability through the legal system, and some of us have not. So I think having that opportunity for the sharing of those experiences and some storytelling within that is really powerful. I have a legal background, and I haven't always had satisfaction from the legal system. So I can see the value in alternative measures and a more sort of holistic response to these issues as well.
Thanks, Amani. Thank you to everyone, but thank you to everyone who've sent comments in and questions. Sorry we haven't got to them all, but we hope this is the first of many discussions as we move into 2021 and looking at what the draft bill might be. I just want to leave you with a closing comment. Quite a few years ago, when Brian and I were doing training together, we brought to Australia Dr. Ed Gondorf. If people have read his work, which is pretty thorough in terms of what might work with perpetrators. And his comment is the system matters. And I think the system does matter. And I think that it can be a very cruel and harsh place for victims. And so my position is that we certainly need to reform it. And I'd really like to see a complete reform of the justice system in Queensland as it is. But thank you, everyone. Appreciate your time, appreciate the panel. And we look forward to further conversations.
Thank
Have
you,
a great
Betty.
day. Thank you, everyone.
Thank you.
Thank you.